Former President Donald Trump slamming the woman accusing him of rape as fake, saying he'll probably attend the trial.
And I have to go back for a woman that made a false accusation about me, and I have a judge who's extremely hostile. And I'm going to go back and I'm going to confront this one. This woman is a disgrace, and it shouldn't be allowed to happen in our country.
So closing arguments in E. Jean Carroll's case against Trump are set to start on Monday. The former president has not appeared in court during the span of the 7-day trial. His attorney says he still doesn't plan to testify. The judge, however, is giving the former president until Sunday at 5 p.m. to change his mind. Carroll is suing Trump for battery and defamation. She says he raped her in a Bergdorf Goodman dressing room in the 90s and then lied about it, destroying her reputation. Trump says it never happened. CNN's Kara Scannell joining us now. So, Kara, both sides have rested their case, but now we have, I guess, this little window until Sunday at 5. So now we just wait?
What an unexpected twist that happened yesterday. So Carroll's attorneys rested their case after calling 11 witnesses. You know, Carroll herself testified. Trump's attorneys said they were not putting on a defense. They thought about calling an expert witness, then didn't. And Trump's attorney had said that the former president was not coming. Then, of course, these comments overnight were hanging in the air all day yesterday until the end of the day. The judge asked Trump's attorney, "Are you resting your case?" This was outside the presence of the jury. He said, "Yes, I am." He said, "Does Trump waive his right to testify?" He said, "Yes." And then the judge said, "Well, I'm going to give you to 5 o'clock anyway," kind of acknowledging that Trump's attorney can't control his client. So he's saying, you know, just to protect the integrity of this trial, I'm going to give you until 5 o'clock to say for sure whether you want to do this. And the judge said, it doesn't mean I'm going to grant it, but I'm going to allow this space. And but they then went straight into conversations about the schedule, how closing arguments will take place Monday, and the jury will get it as soon as Tuesday.
And I think one thing is Trump's lawyers don't always speak for him. You know, obviously we saw that many times in the White House. He wasn't there in person, but they did hear from him in a deposition that I think was done in October. What is he saying in this deposition?
Yeah, so they heard about 30 minutes yesterday, and they heard about 25 minutes the day before. And, you know, in this deposition, Trump is kind of sitting hunched over, pretty still, you know, answering the questions. But it's the first and only time the jury will hear from Trump, as of now, you know, address these specific allegations in the case. It was your regular Q&A, but then they were confronting him with some of his own comments, including the Access Hollywood tape, where Trump is there and he's talking about how, you know, he's a celebrity, you know, he just kisses women, he can't help himself. A little bit of the deposition here, it's a videotape. We've asked for it from the court and the parties, and we're working through this process to get it. So hopefully we can bring it to everyone. But here's what he says. He says, well, historically, that's true with stars. And Carroll's attorney says, true with stars that they can grab women by the... And Trump says, well, that's what, if you look over the last million years, I guess that's been largely true. Not always, but largely true, unfortunately or fortunately. And then he's also, though, addresses the defamation claim in this case. You know, this is all based on a Truth Social post he made. And he's, you know, asked, did you write this yourself? And he says, oh, yeah, I wrote it myself. You know, I don't know who this woman is. It's a hoax. She's not my type. And then he says to Carroll's attorney this: you wouldn't be a choice of mine either, to be honest. I wouldn't, under any circumstances, have any interest in you. So certainly not taking a more demure posture in his deposition from the Trump that we see often in these campaign speeches.
Yeah, certainly not.
No, I'm going to leave that one alone. Kara, appreciate it. Thank you.
Thanks, Kara.
CNN anchor, senior legal analyst, and former federal prosecutor Laura Coates joins us. How problematic is that video deposition of the former president? Apparently kind of backing up what he said on the Access Hollywood tape, just saying that is something that celebrities can often have been able to do.
Now, normally you wouldn't really have hearsay statements, right? Statements made outside of the courtroom admissible. This is an exception that's admitted here in a civil case because it's essentially a statement against his interests. And more importantly, although this has been a Hollywood tape that's been out there since at least his first presidential campaign, it now gives even greater weight to that testimony because now he is not the one testifying. He did not appear at trial. He does not have to appear at trial in a civil case, which is very surprising to many people. people. But because he did not do so, because he is yet to testify and may not ever testify now that the defense has said he will not, it gives greater weight to what was said. And so he's not going to counter it. He will not clarify the statement. And that just sort of rests there before the jury to consider, well, then is there more credit to be given to E. Jean Carroll's testimony?
Kara Scannell just mentioned this. I want to play the clip of the former president who's in Ireland saying he'll head back to New York to appear at the trial.
And I have to go back for a woman that made a false accusation about me, and I have a judge who's extremely hostile. And I'm going to go back and I'm going to confront this one. This woman is a disgrace, and it shouldn't be allowed to happen in our country.
I mean, it's not really clear, as with many things, what he's saying. He's saying he's going to go back. He's not saying he's going to testify, just he's going to go back and confront whatever that means in Trump speak.
Whatever that means. And of course, it does have actually a legal definition, right? You have the opportunity and the right to confront an accuser and to confront a witness testifying against you. If he meant it in the legal sense, well, his attorney has contradicted that and said he's not going to put on a case. He's not going to present evidence. He's not going to be the person to actually do so in a courtroom, in a court of law. The judge, however, is being very prudent here. Those statements seem to contradict what his attorney is saying, and there is an abundance of caution that is really demonstrated by judges to ensure that somebody who otherwise has a right to confront one's accuser, who has a right to testify in a case, will have every opportunity to do so. Why? Because most judges are afraid of being appealed in a way that says the judge did not do enough to secure and protect the rights of anyone accused, even in a civil context. But as the judge noted, unless he says he will intend to do so by Sunday, then that ship has sailed. Frankly, the fact that he already said he's not going to do so would mean that ship is well along the horizon at this point in time. But out of an abundance of caution, given the stakes of a case like this, the actual person who is being accused, a former president, I suspect he's trying to extend that abundance of caution here.
I want to ask you about the new developments in another case involving the former president. The New York Times, as we mentioned, is reporting tonight that the federal prosecutors investigating Mar-a-Lago documents have obtained a confidential cooperation of someone who worked at Mar-a-Lago. The person's identity obviously hasn't been disclosed. Potentially, it sounds like, I mean, that could be significant depending on what access that person may have had.
Absolutely, Anderson. I mean, think about this. Remember, it's not just that documents were no longer in the White House or that they were transported to Mar-a-Lago. It's also that there was a whole lot of intervening circumstances where the actual government was saying, we'd like these back. The archives, we know that you have something. Please return them, and was able to actually delineate certain things that were there. So if there was a moment in time where documents were, one, where they were not so supposed to be, they came after a subpoena, and in knowing that there was a subpoena active to try to retain and return these documents were moved, documents were put from one place to another in some effort to try to conceal documents or their existence or to keep them out of the rightful hands of the owner. Well, then that now thickens the plot here. And so any cooperating witness, although the identity we do not yet know, I don't want to get ahead of my skis, the fact that you have somebody who might have some insight as to what happened once there was actual notice given that documents were knowingly on that premises and were not returned, well, what happened in the interim? That is the heart of Jack Smith's case.
Yeah. Laura Coates, great to have you on. Thank you so much.